One of the worst things I've had to deal with in construction law is getting a call from a homeowner who had a lien claim filed by a subcontractor or material supplier. The person says that they paid the general contractor in full, and now the subcontractor or material supplier wants to get paid because the general contractor kept all the money. In the world of construction liens, we call that double jeopardy. In layperson's term, this is called paying twice for the same thing. The bad news is that under Wisconsin law, there are times when a homeowner must pay twice. A subcontractor or material supplier with a valid lien claim can lien your property even if you paid the general contractor in full. Also, because a subcontractor or material supplier has 60 days or more from the start of the subcontractor's work or the date materials were first supplied to provide you with a lien identification notice, you may not even know about the subcontractor or material supplier until after you paid the general contractor in full. So how do you avoid paying twice? The first and most important thing to do is never hire a general contractor that doesn't have a great reputation or that doesn't have great references. When you hire a general contractor, insist on getting a list of the contractor's subcontractors and suppliers, and get a list of material suppliers for the subcontractors as well. If you get a lien identification notice from a subcontractor or material supplier, make sure the subcontractor or supplier was disclosed to you. If not, find out why not. Also, many of these notices will come via certified mail where you sign for them. If you get a notice from the post office that an attempt to deliver mail was made, make sure you get your hands on the mail. Some courts have held that even if there was only an attempt at delivery, that constitutes proper notice, and they've made the homeowner pay twice even when they never got an actual identification notice from the subcontractor or supplier. Just the fact that a mail carrier tried to deliver a notice was enough to perfect the lien right. Make sure that before you make any payments, you have valid lien waivers in place from the general contractor, all subcontractors, and all suppliers for the project. Those lien waivers need to cover all work and all materials for the payment being made. If you do end up in a situation where a subcontractor or material supplier is claiming lien rights for work or materials you've already paid for once, contact an attorney immediately. Lien law is very specific, and not all lien claims are valid. There may be a way to invalidate that lien, but you are always much better off by avoiding the lien claim in the first place. You avoid lien claims by knowing everyone you're doing business with, including all subcontractors and material suppliers. You avoid lien claims by getting lien waivers from everyone you're doing business with or who is supplying materials whenever you make any payment. You avoid lien claims by making sure that you read all lien notices, and if you see that a mail carrier has tried to make a delivery to you, follow through and track down that piece of mail and read it. If you have any questions about liens, feel free to call or email me, but please don't provide any confidential information in an email or voicemail as I represent numerous contractors and subcontractors.